First of all, good morning, everybody, and thanks very much for taking the time to join the webinar this morning. For those who don't know me, my name is Paul Brown, and I'm one of the tax partners at WR Partners, and I'm your host for this morning. Fortunately, because we're virtual, we don't need to worry about fire alarms. If you hear a fire alarm, it's yours, so you'll need to deal with it. But as I say, really grateful for you joining us. This is obviously, we've had a great attendance for this morning's session, which I think shows how much of a potential concern these new IR35 rules are for people. So hopefully, between the three speakers this morning, we'll take you through the various aspects of IR35. And hopefully equip you with enough information to start preparing, if you haven't already, to make sure that you're ready for the rules when they kick in April. I'll let the other speakers introduce themselves in due course, but just very briefly, we're really pleased to be joined by John Merry from Lanyon Bowdler, who's a partner there, obviously, and John will talk you through some of the contractual aspects of IR35, and my colleague Jenna Tarry, who's our HR consultant, will then talk you through some of the practical aspects of dealing with the workforce from an IR35 point of view. But in order to avoid me having the graveyard slot, I'm going to be kicking off and talking about some of the tax implications of IR35 and really just giving a bit of context for the discussion. Just to let you know, the webinar is being recorded, so it will be available on our YouTube channel in due course. And I'll remind you at the end, but there will be there's a short questionnaire, a short feedback questionnaire that it'd be great if people could complete as well. The way that we're going to run this is we'll each run our session, and then we'll try and pick up a few of the questions that might come up after the session, and then once the three sessions are done, we'll kind of sweep up any other questions. So if you do have questions, if you could please pop them into the Q&A box, and then we'll monitor those as we go along. So the Q&A box should be at the bottom of your screen. Pop them in there. As I say, we'll spend maybe 5 minutes at the end of each session just answering some of those questions, and then do a sweep up at the end. So the objective is that we'll be finished by no later than midday. I hope you enjoy the session. And so without further ado, if you just bear with me for I share my screen, then hopefully everybody will be able to see this. So as I say, contact details there, which, as I said, will be sort of available via the YouTube video as well. So my section talking about the tax perspective of IR35, and I think probably, although I would imagine a lot of people, if you've joined the call, you're aware of what IR35 is. I think it's probably useful just to give a wee bit of context around it. So that everybody talks about IR35, but the official name is actually the off-payroll working rules. But I think you'll all agree that that's a little clumsy. So I think typically and throughout the session, we'll refer to IR35. I think it really applies to workers who are providing their services through their own limited company. Now, when I say limited company, it can extend to other types of intermediaries, is the term that's used in the legislation. But for all practical purposes, the vast majority of situations we're going to see is where the individual's providing services through their own limited company, which is for shorthand known as a personal services company, or PSC. And I guess the question that the IR35 rules ask is, if you took the company out of the equation and you looked at the services and the way the individual provides their services to their end client, would you look at it and say, well, it looks like and kind of smells like an employee type relationship? So if you answer yes to that question, if you took the company out and the individual looks like an employee of the client, then the IR35 rules are going to apply in that situation. So why is it changing then? So I think it's fair to say, first of all, that the IR35 rules have been around for a great number of years. But the big change that we'll talk about is that historically the onus was on the personal services company itself to decide whether the rules actually applied or not. So it wasn't actually, it was kind of almost a self-assessment system in truth. And the reality of the situation, probably that only a small proportion actually did ultimately look at it and decide that the rules applied. Anybody who did consider it did actually ultimately, decide that the rules didn't apply. But the reality is a lot of PSEs really just ignored it. So in 2017, the government put their toe in the water in terms of changing the rules by rolling these new rules out to the public sector, first of all. So engagements between public sector organisations and people with their own PSCs were brought into a new rules where essentially the onus was placed on the public sector body to determine the status in the arrangement rather than the PSC. So kind of it was putting the onus on the public sector organisation to decide whether that employment-like relationship did exist. If they decided that it did, then essentially there was an obligation on them to operate pay-as-you-earn on the payments that were made to the personal services company in that situation. And so the real reason why this is changing, let's be brutally honest, is they tried it with the private sector. It raised something like £550 million. So they decided, actually, do you know what, that's not a bad idea. Let's roll it out to the private sector as well. Forgive me if I sound a little cynical about some of this. So what are the key changes then around IR35? So from April 2021, the onus is going to be on large and medium-sized clients to determine the status of their off-payroll workers, so their workers providing their services through PSCs, and determining whether that employment-like relationship exists in that situation. Now, it's very clear that the rules apply to large and medium-sized clients. So what does that mean? Where do we draw the line? So if you're a small client, the new rules don't apply to you. And when I say client, it's the end user of the PSC services, if you like. So if you're a company or an LLP, then the rules essentially say, to be a small client, you've got to have 2 out of the 3 of the following. So you've got to either have a turnover of less than 10.2 million, gross assets of less than 5.1, or less than 50 employees. So if you take 2 of those boxes as a company or an LLP, you're a small client, and essentially the rules revert back to what the old rules were, which was it's the kind of the PSC that has to make the decision about whether the rules apply. They've introduced what they call a simplified test for other partnerships, i.e. non-LLP partnerships and sole traders, where really if your turnover is below 10.2 million, again, as a client rather than as a PSC, then the new rules don't apply to you. If the new rules apply, then the body that's paying the PSC will have to withhold pay-as-you-earn and pay national insurance contributions on the payments to the PSC. Now, in a lot of cases, there's going to be a direct engagement, but essentially you can find a situation, obviously, where there might be a supply chain where the client actually engages with an agency, which then provides the services of the worker through their own PSC. And really what we're looking at here, although the rules are slightly more complicated than this, fundamentally you're looking who's the one who's ultimately paying the personal services company, who's the one that actually is making that payment. And if once you've got to that, once you've determined that, then they're the ones that have the obligation to operate pay-as-you-earn and so forth. And essentially, worst case scenario, if there's non-compliance, in other words, if you either ignore the rules or you don't implement the rules properly, then the pay-as-you-earn and NIC liabilities can be passed on either to the client in the work, if the client doesn't fulfill its obligations, or if the pay is an agency and they don't fulfill their obligations, then the pay-as-you-earn and NIC liability can pass on to the agency instead. So we talk about this employment-like relationship. So what does that actually mean? What are the factors that we need to consider when we're looking at whether an employment-like relationship actually exists? The reality is this is not new. This is something that's always applied to individual contractors, and it still applies to individual contractors who don't have their own PSCs. But essentially, there's kind of a series of tests that you have to look at. The first of which is control. To what extent does the client, the user of those services, actually control when, where, how those services are delivered? The more the degree of control, the more it kind of looks and feels like an employment relationship. Whereas if it's the worker that kind of says, well, I've got to do this job, but it's up to me when, where, and how I do it, then that kind of makes it feel more like a genuine third-party contractor relationship. Substitution's a big one. And I think John touches on, we'll potentially touch on some of this stuff again. Substitution says, well, if I'm the worker and I can't turn up, can I just send somebody else to do the job for me without necessarily the client actually being able to have any say in that? If you can, as a normal employee, you wouldn't be able to do that. Alice couldn't say to WR partners, I'm going to send my friend to do my job today. But if you're a genuine contractor relationship, the client really is only interested in getting the job done. They don't care who it's done by. So if you can make that substitution, it starts to look like a non-employment relationship. The next test is financial risk, which is really looking at, are we, is the contractor, is the worker actually bearing any financial risk? And that can be as simple as they're having to provide their own insurance. If something goes wrong, is it at their cost? It has to be fixed. Again, the more financial risk, the more it looks like a genuine relationship, the less the IR35 rules are likely to apply. And the final one is kind of integration. To what extent is the individual integrated into the client organization? So if they've got an email address with the client, if they appear on the website as part of the team, if they're subject to the kind of performance management system within the client, it makes it look more like an employment-like relationship, in which case the individual, will potentially fall within, or the relationship will potentially fall within IR35. There's no silver bullet, there's no right or wrong answer. It is a case of weighing up all of the factors and reaching what's a reasonable conclusion. Now, HMRC kindly provide their CEST tool, Check Employment Status for Tax, which is online, and the link is there for you to use in due course. And that is a tool where it asks you a series of questions and it spits out a determination at the end. And what HMRC have said is if you answer the questions accurately and it says that the relationship is not employment-like, they will respect that. The reality, though, is the tool's a pretty blunt instrument. It throws out too many uncertain status returns. And I think probably the other point there for an old cynic like me is, if you're HMRC and you're going to build a tool, you're going to be inclined to weight it more towards the answer that gives you the result that you're looking for. Now, I wouldn't suggest, of course, that they do that consciously, but maybe, there is an element of that in there. But nevertheless, it is a useful tool. And if you answer the questions honestly, and it says it's not an employment-like relationship, HMRC will respect that outcome. So in terms of what the process is, essentially this nice flow chart that we've got here says the client business, the end user of the services, makes a determination based on the factors that we've just talked about, and they have to take reasonable care. They can't just have a stab in the dark. They've got to make a reasonable effort. Having determined the status of the worker, they have to issue the PSC and potentially other parts of the supply chain, if there is one, with a status determination statement, which says we've concluded that either the IR35 rules do or don't apply, and gives reasons. So once the PSC has ultimately received that status determination, then they've got the right to object within 45 days of the day that they receive it. And they can give their reasons why they think the determination is wrong. The appeals process, however, is back to the organisation that made the determination in the first place, the client. So one would hope that the client would be sufficiently open-minded, and actually if there's other information, they would form a view. But it is essentially the client is not only the one who makes the determination, but they're also the one who decides whether the determination is right in the event that the PSC objects. Once that determination has been decided, then there's effectively no right of appeal beyond that point. So that, I think, is a summary of the tax aspects. I appreciate that was a real very quick canter through, but just have a quick look in the Q&A box if I can get it to open. Which
we've got one question, Paul. Do you want me to quickly read it out?
Yeah, please, Alice, if you may.
So a question from Shelley. What if the client doesn't provide the status determination and still refuses to even sometimes afterwards?
Well, so essentially in that situation, the client now has a legal obligation to prepare that status determination statement. So in the absence of a status determination statement, they've not complied with the rules, and essentially, the pay as you earn and NIC obligation sits with them, rather than with ultimately with the PSC. Now, I think we have to expect that HMRC are going to be enforcing these rules. A lot of you may have heard about this concept. They're saying, well, we're going to have light touch enforcement. We're going to, it's going to be a soft landing, but ultimately the soft landing is only around penalties. It's not around people actually making sure that they comply or attempt to comply with the rules. I think, unfortunately, that the rules don't provide the PSC with a great deal of, ability to force the issue. I guess ultimately you could approach HMRC. It's up to you whether that's something that you feel comfortable with. But the exposure rests with, if the client refuses to make a determination, continues to pay the PSC on a gross basis without thinking about what the nature of the relationship is, then that is very much at the risk of the client rather than the PSC, I guess.
And another one from Kirsty: do you have to use a CEST tool, or is it just good practice?
There's certainly no requirement to use it. I'm not even sure you'd necessarily say it's good practice. I think it is useful. What I would say is, if you use it and it produces an answer which you don't agree with, you're not obliged to follow it. So in one sense, you almost lose nothing by it. If you answer it honestly, and it, because the tool can't deal with the subtleties of every situation, it's inevitably going to throw out unexpected results, and there may be something in the relationship that doesn't necessarily fit within the tool. So, my suggestion in many ways would be, use it, answer it honestly. If it produces the answer you were expecting and feel is appropriate, take no further action. If you think the tool hasn't worked properly, or it's spat out a result which says your status is uncertain, you're not obliged to follow it. Have a look at the circumstances and make a determination based on the information that you have anyway. So. Brilliant.
We've got a scenario question here. So how are we affected? They're a small business not covered by these rules, but we supply contractors to a large company who are included, and we're a paper supplier, and the large company is the end user.
So essentially, so you're effectively, I think, in that scenario, acting almost as an agent then in that. So I think hopefully I'm interpreting the scenario correctly. So you do, as a sort of somebody in the middle of the supply chain, you do have certain obligations. So if the client ultimately has to make the determination, but they then have to pass, if you're the payer, the client will pass you the status determination statement, as well as going to the PSC. And if that says this is an employment-like relationship, then as the payer, you're going to have the obligation to withhold pay as you earn, and potentially, well, in fact, not potentially, you will have an employer's national insurance obligation in that situation as well. But you're kind of stuck in, you're kind of betwixt and between in the middle of the supply chain, because you don't actually have a right of appeal against that status determination statement. It's only ultimately the personal services company that has that right of appeal. So you're kind of at the control or at the behest of other other people at the top and at the bottom of the supply chain in that situation.
I think they've just replied and said we suspect the large company will tell us what we have to do to the assessments.
Yeah, I think that's right. It's up to them. They're the ones who are the end user of the services, so they're the ones who will have to ultimately make that determination.
We've got one last one. It's a bit of a long one. Recontrol. Can you elaborate? If a consultant for a marketing organisation, there is likely to be collaboration on how things are done, and then rely on expertise of consultant to execute. Is this deemed to be them controlling how they implement services, even though they are working alongside clients' wishes?
I think it comes down to a question of fact, and that's a classic tax person's way of trying to dodge answering the question in a definitive way. But I think, if the client says to you, I want you to deliver this product, and this is, but it's up to you to deliver it and how you go about doing it, then I don't think there's a great element of control there, because it's a bit like, if I get a plumber around and say, I want you to fix my sink, I'm telling them what needs to be done, but I'm not then telling them how they need to do it. So I know it's probably quite a poor example, but if it's a case of you're collaborating to reach an end result that the client is looking to achieve, I don't think that's control. If, however, the client says, I expect you to be in our office Monday to Friday, 9 till 5:30, I expect you to take your lunch at 1 o'clock. I expect you to follow our processes and procedures. If you want to not be here, you've got to ask for holiday, then that's the kind of degree of control that we're looking at. But control is only one of the factors. So, you need to also weigh up the other factors within the relationship as well.
Perfect. That's all of them answered.
Great stuff. Thanks, Alice. Hopefully that was useful. And again, if there's any other tax questions that occur as we're going through, please pop them in the Q&A box, and we'll pick those up at the end. But without further ado, I'll hand over to John Merry to talk about contract aspects of IR35. Over to you, John.
Thanks, Paul. Yeah, for those of you who don't know me, I'm an employment lawyer. I'm the head of employment at Lanyon Bowdler Solicitors. And one of the areas that I advise on is employment status, or deemed employment status, in the context of IR35, including preparing and advising on contracts for use by or with independent contractors, either directly or through service companies. And today, of course, I'll be talking specifically about the application of contracts in the context of IR35. So if we can have the next slide, Paul. Thank you. A golden rule in relation to any commercial agreement is, of course, to make sure you have a well-drafted written contract in order to provide certainty as to terms. What does well-drafted mean? Well, in the context of IR35, it doesn't necessarily mean representing on its face that IR35 doesn't apply. In an ideal world, yes, the parties might prefer that it doesn't, but will this actually be possible in practice in the circumstances taken into account the parties' requirements? If commercially the services need to be provided by a particular person in circumstances where there'll be deemed employment, IR35 will apply, then so be it. The contract documents should reflect the reality. There's no point trying to concoct a written agreement that tries to represent that IR35 doesn't apply. Remember, of course, HMRC will look at the reality of the situation. But if the services are going to be performed in circumstances and on terms in which IR35 won't apply, then it is important that the contract documents reflect and support that position. And what I'm going to do in a moment is highlight the kind of factors that will point away from deemed employment status and reduce the risk of IR35 applying. Remember, though, that IR35 shouldn't be the only consideration. Whether it's to apply or not, there are other important contract points to bear in mind, and I'll run through what I'd say are the main other considerations further on. If we can have the next slide. So what terms will avoid or at least reduce the risk of IR35 applying? The most important contract will be that between the end user client and the intermediary which engages the individual who's to perform the services. As Paul said, that will usually be a service company, of course. Sometimes, as Paul said as well, there'll be an agency or another chain of contractors between the client and the service company. That's fine, that the same principles apply, albeit in the context that there would be looking at the terms on which the end user contracts indirectly with the service company. Although by no means determinative in itself, it's helpful to reflect in the contract documents that the relationship, any relationship between the end user client and the service company is that of client and independent contractor. Beyond that, by no means all of the points that I'm about to set out need to be applied to avoid the application of IR35. Some, in fact, will kill deemed employment stone dead when they genuinely apply. Others will contribute towards that picture. But suffice to say, in basic terms, the more of the following principles that you can apply, the less likely it will be that IR35 will apply. It's no coincidence that some of the points that I'm going to talk about have been touched on by Paul already in explaining the concept of IR35. in this context, it's about applying those principles in the paperwork to the extent that we can. So Paul's touched on substitution. If we can take the company away, if we analyse a situation as if the company wasn't there, and there's no obligation for personal service by a particular individual, you can't have deemed employment. So if you can enable the service company to appoint someone other than the individual behind it to perform the services, ideally there should be an unfettered right of substitution, because a conditional one may or may not be consistent with personal service and therefore deemed employment. If we move on to the next slide. For example, a right for a different person to perform the services only when the individual behind the company is unable to carry out the work, or with the consent of the client in its absolute discretion, would tend to be consistent, in fact, with personal service. But in contrast, if the only limit on the right of substitution is a need to show that the substitute is suitably qualified, that would tend to be inconsistent with personal service. Next slide, please. The important thing is to consider whether the exercise of a right of substitution will actually work in practice. Of course, the nature of the services or otherwise the client's requirements often mean that it can only be one particular individual who can do the work, and in that case, substitution isn't an option. But if you are to have a substitution clause in the contract, bear in mind that putting it there and exercising it are two different things. It may not be enough just to have the clause. If it's there but you can't evidence rather that it's being exercised in practice, then you're vulnerable to a challenge by HMRC that it's not a genuine right of substitution. If we can move on to the next slide. So other things you can do to avoid or reduce the risk of IR35 applying. If you can, avoid an obligation to provide and accept work. In other words, avoid mutuality of obligation. Without mutuality of obligation, you can't have deemed employment. Continuing in the same vein, a related point is where you can provide for termination of the relationship without or on very short notice. If you can, avoid or minimize restricting the service companies or the individual's right to provide services to others. Next slide, please. It's important to subject the service company and the individual contractor behind it to as little control as possible. So ideally, they should be free to set their own hours and location for performing the services, and they should be free to determine how the work's done. Supervision really should be kept to a minimum, limited to such things as checking compliance with quality standards and the like. If you can, structure contracts by reference to completion of a project or a piece of work, and make payment by reference to completion of the task rather than the time worked. If we can have the next slide. Paul talked about financial risk. It's important, if you can, to provide for financial risk and reward other than the mere payment of fees. You might have penalties for late completion of work or bonuses for early completion. And another step you might take and should take if you can is to require the service company to maintain insurance against claims arising from its services. Integration is another point mentioned by Paul, an important one. Avoid as much as you can integration of the individual into the end user's organisation. They shouldn't be held out to be a member of the company if possible. They shouldn't be wearing a uniform or otherwise badged up as if they're part of that organisation. And they certainly shouldn't be subject to the end user's internal procedures, such as disciplinary or grievance procedures or appraisal systems and so on. Wherever possible, require the service company to provide its own equipment. And finally, in this regard, where possible, allow the service company and the contractor to retain intellectual property rights such as copyright, trademarks, design rights, and so on, created in the course of providing the services. Of course, it's often important to the end user or one of its clients, say, to acquire the benefit of intellectual property, in which case so be it, but to the extent this isn't necessary, allow the IP to remain with the service company / the contractor. Moving on, next slide, please. Other considerations then than IR35 to bear in mind when preparing these contracts. Commonly, the end user will wish to protect its confidential information and other property. As I've mentioned, the end user will often wish to secure IP rights for itself or a third party, and where that's to be done, the end user should ensure that the chain of contracts from the contractor up give effect to that. As regards data protection, the client's processing of the individual behind the company's personal data should be subject to a privacy notice. And if the service company will process data on behalf of the client, then the data protection legislation requires that certain terms should be included in the contract, including relating to the scope, nature, and purpose of the processing and requiring data protection compliance by the company. Next slide, please. End users will be well advised to include an indemnity in respect of tax and national insurance contributions not intended to be deducted by them, but bear in mind it's not possible for end users to secure an enforceable indemnity in relation to employers' NICs. Purported indemnities of that nature are unlawful. And finally, on this point, end users would be well advised to include an indemnity against employee or worker claims by the contractor. Next slide, please. I'm now going to say a few words about side agreements with individuals behind service companies. The end user should bear in mind that if it only has a contract with a service company or a chain of contracts concluding at the service company, the individual behind the service company will avoid all possible personal liabilities. So if there's some kind of breach of contract or negligence or a need to recoup a payment or to enforce an indemnity, the end user client can be left with nobody to sue other than a shell company. And for that reason, when advising end users, we recommend that there's also a side agreement directly with the individual, guaranteeing certain of their company's obligations. Next slide, please. So what kind of things should the client look to include? Well, we'd recommend that there's a warranty as to ownership of the company, a warranty that the company is entitled to enter into the agreement. So, for example, there's no issues with restrictive covenants. The real key one is an agreement to procure that the company will observe and perform the obligations contained in the agreement and indemnify the client in respect of breaches. And finally, IP provisions. As I've mentioned, if the end user client is to secure IP rights for itself or a third party, it should start from the ground up. Next slide, please. Finally, just a quick word about contracts between the service company and the individual behind it. It can help to a degree in the context of IR35 if there's a written employment contract between the service company and the individual. I'll say no more than that. It should look like a standard employment contract, and it certainly shouldn't link the individual with any end user clients of the service company. And that concludes the points I wanted to run through. Do we have any questions directed at me, Alice?
Yes, we've got one from Craig. What is considered short notice? The majority of my previous contracts have been 1 week. Is that reasonable amount to deem short?
yeah, that's pretty short. I mean, ideally, the aim would be no notice at all. Sometimes that isn't practical, but yeah, 1 week would qualify as short. Yeah.
And then another one, if determined to be inside IR35 as an employee, who is obliged to pay the employer's national insurance and pension contributions?
That's an end user obligation.
Okay, and then from David, there's only one of me in my limited company. Should I have an employment contract with Limited Co?
Yes, I would say so. It's not, as I've indicated, it's not the most important consideration, but it's part of the picture.
Brilliant. There is another one you might be able to answer that came through whilst you were talking. We have a few clients who work as a contractor for just one end client, but that end client is an overseas company. Do the off-payroll rules apply to a medium or large overseas company, or is it just the case that old rules apply regardless of the size of the overseas end client? So PSC should still determine their own status.
Correct me if I'm wrong, Paul, but I think that's outside the considerations, isn't it? Because it's an overseas company.
Yeah, unless they've got a business presence in the UK, then it falls outside the considerations. It has to have either UK resident company or at least a business presence in the UK. That's exactly right, John.
No more contract questions.
Okay then, so on to Jenna.
Good morning, everybody. So just to give you a bit of a quick introduction, I've recently joined WR Partners as a HR consultant. So providing services to support clients and companies with the here and now in any employment related matters, but also to support them on their journey, providing strategic employment advice and delivery for where they want to go to. So purpose of my discussions today is just to give you a brief sort of summary really on some practicalities of considering preparing for IR35 and some of the steps you need to do along the journey. So can I have the next slide, please, Paul? Okay, so who is responsible for IR35? Well, for some, there is a large project to be completed by April in assessing the true working relationships for existing contractors. So we've all got to remember it's not just a one-off event. So from April, you will need to have processes which will need to be implemented that deliver fair and consistent outcomes each time contractors are engaged or renewed. Where they are renewed, you'll need to obviously review regularly to make sure that there's no changes in the working relationships during that period. The systems you use will need to collect and store assessments in case it's subsequently challenged either internally by the contractor or externally by HMRC. Your internal processes will also need to be evaluated to ensure that no new contractors are engaged or commence delivery of services prior to an assessment taking place. Next slide, please. So consideration should be given as to who will actually complete the ongoing assessments which are now required, and if any additional support is required to ensure that there is full understanding of the testing criteria. Whilst the assess tool, which Paul mentioned earlier, will aid some decisions, it is encouraged for this not to be the only assessment completed, owing to it not being 100% accurate. Therefore, those completing the assessments need to be competent in their understanding and of the test factors, which may require additional support and training. Next slide. So what is going to be communicated during the preparation stages? Well, communications during assessment are encouraged to ensure that contractors are fully aware that A, the assessment is being completed, B, what is actually being assessed, and C, highlighting any areas considered as either inside or outside payroll. Having open discussions during assessment stages could mean that simple adjustments can be made, although caution should be applied as the contract needs to be a true reflection of the practices in place, as John mentioned earlier. Open dialogue can also help to alleviate any potential disputes surrounding the outcome of the assessments completed. Dialogue between both parties during the assessment will help to ensure understanding allow contract input, and allows opportunity to make adjustments where possible. If it is envisaged during the assessment that a contractor is likely to be regarded as inside payroll, it would be wise to commence discussions surrounding how this would impact the contractor and seek a mutual way of moving forward. For example, if you want to retain the services moving forward on a long-term basis, discussions may need to be held to negotiate new rates to compensate for any deductions the contractor may face. If it seems unlikely that you'll be able to retain the services, this allows opportunity to seek new service providers in a timely manner. Once a decision has been reached, the outcome needs to be communicated in a status determination statement, as Paul mentioned earlier, which must include details surrounding the decision reached and the reasons which have led to the decision. The statement needs to be shared with the contractor and the next party in the supply chain. Verbal delivery of the outcome is encouraged to allow full understanding and for the next steps to be agreed, including how the contractor may challenge the outcome. Next slide, please. Whilst contractors are not employees and therefore do not have the right to appeal, they do have the right to challenge the assessment via a status disagreement process, which Paul referred to earlier. This process is client-led, and a final decision must be reached within 45 days from the date the disagreement is received. Therefore, there is no time limit as to when a challenge needs to be raised, but you would want to assume that the challenge would be made immediately, as the contractor would be subject to the deductions once the agreement has been reached. It is encouraged for the status disagreement process to be planned to ensure a full understanding of who will handle such challenges and timescales involved. And you may also want to consider documenting this process in order to have complete transparency. Next slide, please. It may be appropriate for the same person or the people who are completing assessments. Sorry, I think I missed a bit here. So it may be appropriate for the same person or people who are completing the assessments to communicate details of the assessments and outcomes in order to provide continuity. However, if there are a large number of assessments, consideration should be given to the time each element takes. It may be deemed that a separate communications team is needed. However, internal handovers will need to be required to ensure that the communicator is fully aware of the background and how that outcome has been reached. Consideration should be given as to who will handle any statement disagreements, as an independent from the assessment should handle the disagreement process in order to demonstrate that a fair and reasonable process has taken place. Disagreements can be received verbally, which need to be logged as the clock starts ticking from the date the verbal complaint is received. So how are we going to obviously communicate? Well, personal direct communications are encouraged owing to the complexity surrounding Ir35. However, as a result of the ongoing pandemic, which I'm sure we're all used to now, if they can't be delivered in a personal, safe manner, you can consider having remote meetings or telephone. Discussions should be noted or recorded in order to refer back to at later stages. For example, if a contractor is going to challenge the outcome or if there is a HMRC inquiry. However, the recording of meetings is only just encouraged as best practice, it's not actually required. So the outcomes of any assessments need to be communicated in advance of any payment. Sorry, next slide, people. So the outcomes of assessments need to be communicated in advance of any payment being made for services delivered on or after the 6th of April. Therefore, in regards to timescales, it may be necessary to send the status determination status prior to the 6th of April in order to comply with the new legislations. Okay.
Brilliant. We have a few questions, Jenna. Is there a standard format for status assessment determination?
There isn't a standard format, but there are some sort of key regulations as what needs to be included. So as I said, it is the reason and obviously how that reason has been reached.
Brilliant. And another question, what are the penalties for non-compliance? Might be a bit of a
I think this is a Paul question, probably.
So I think the initial penalty, I suppose, is well, there's two aspects to this. There's first of all, as I say, if either say the end user, the client, doesn't comply, decides just to effectively ignore the system, then the potential is that the actual pay-as-you-earn, the NIC liability lands on them, irrespective, even if they're not ultimately the payer of the PSC's remuneration. But beyond that, the usual penalty rules are going to apply, where if you fail to take reasonable care, there can be penalties which range anything between sort of 10 and 30% of any tax that's lost. Potentially, if HMRC decide that you've kind of deliberately not followed the rules, the penalties can go up to 70%, and ultimately, in the worst case scenario, it can be 100% of the tax that if HMRC conclude that not only have you deliberately ignored the rules and acted deliberately to sort of get round them, but also have kind of tried to hide that fact as well, you can have a penalty of up to 100% of the tax. And I think this links back to this point about the soft landing. So yeah, absolutely, HMRC might take a more relaxed view on penalties in the short term, but there's absolutely still going to be, there's nothing to say that they'll take a soft landing in respect of actually applying the pay-as-you-earn in NIC in the event that the system isn't implemented correctly. So
a big one then. Okay, there's some more general questions, so if anyone wants to shout up once I've asked them.
Shall I stop sharing, Alice?
It's up to you, yeah. So from Paul, if I have an external telesales working on billed hours using my CRM, is this classified as an employee?
Well, I mean, we've got to remember as well that there's employment for employment law purposes and there's employment for tax purposes. So IR35 is only a relevant consideration where the individual's providing work through their own service company or other intermediary, and that's is the deemed employment for tax purposes. And a separate consideration is whether employment in the employment sense, employment tribunal sense. So if that telesales person isn't operating through a service company, depends whether the tests for employment apply. If they are operating through a service company, they can't be an employee or worker in the sense of employment rights. Whether they're whether IR35 depends whether they pass the test for deemed employment status or not.
Yeah. And one from Claire, do these rules apply to sole traders?
Well, I think it's John, two aspects. If you're a sole trader with a turnover of more than 10.2 million, then if you're using contractors, then yes, absolutely, you have to do a status determination statement. If you're a sole trader and you're providing the services, I think, as John kind of suggested, then you're not within the strict IR35 rules because there's no intermediary, there's no personal services company there. But the tests still apply to determine whether there still is an employment relationship, and that's something that HMRC have looked at for many, many years to try and say, well, you might say you're a contractor, but in fact, looking at the facts and circumstances, we're actually going to treat you as an employee for tax purposes only. That I wouldn't even, want to get involved in the discussion about how that works from an employment law perspective. But just because you're a sole trader providing services, you're not within the IR35 rules per se, but there's still a risk of HMRC at some point classifying that relationship as something that should be subject to pay-as-you-earn and national insurance contribution.
Brilliant. So one from David regarding the integration stress test for information reasons, etc. Is it more and more common to have email addresses and in some cases forced to use laptops issued by the client? How is this being viewed by HMRC? That one makes sense.
Say again, Alice, sorry, I missed that, forgive me.
All right, so for information's reasons, etc., it's more and more common to have the email addresses and in some cases forced to use laptops issued by the client. How is this being viewed by HMRC regarding the integration stress test?
I think look, it's not ideal from a, speaking from a kind of tax perspective. And again, John may comment more broadly, but I think having a company, a client email address does imply integration, but it's not the only factor. So, it is a balance. So if one factor, points it one way, but the balance of the other factors indicates the other way, then, it's not fatal to the case. It's just from a presentational point of view, it does give HMRC something to hang their hat on. You do see horror stories out there where people will put, I'm an independent contractor, but then on their LinkedIn page or their Facebook page, they say sales manager at such a company. So things like that aren't helpful as well. So that's more about the perception. It's more about giving the revenue the opportunity to ask the question. But then when you analyse the other factors, you still need to take them all in a balance to decide whether there is actually that employment-like relationship or not. So it's not the end of the world, I think.
And I'd say it's the same with regard to employment, employment tribunal assessment of employment status. Same. It's going to be one of a number of factors considered in the round.
Brilliant. Another tax one, kind of general question. As a contractor, my umbrella company has said I can't claim the working from home tax relief on heating, etc., that the employees of the company have been able to do during COVID. This said the reason is because broadband and heating are dual purpose. Is that correct?
I think it's an interesting one because the revenue do actually, and they increased it, I think, didn't they? So it's some princely sum of about £6 a week from memory, but there is a kind of standard rate deduction effectively, which the revenue will accept as being kind of a proxy for the additional costs of working from home, I think, but that does tend to cover things like heating, etc. It won't typically apply to broadband. So, but as the employee of an umbrella company, you are an employee, and ultimately, you should effectively be treated in the same way as other employees, I guess.
Perfect. 2 more to go. What if an agency just starts taking PAYE with no notice? This happened to me as a subcontractor due to MOD. Is there a way to challenge a status determination that hasn't been supplied?
Shall I take that one again? So I think the difference here is this whole concept of a status determination is new to this iteration of the IR35 rules. So when it was just applied to public sector organisations, there wasn't really this defined communication process and this requirement to, now it's clearly not good practice for the MOD to have just started to operate pay as you earn, but there wasn't this structured process. So going back to what I was talking about earlier in terms of where the obligation sits, the client now will be, if they fall within the rules, will be obliged legally to actually provide the status determination statement. If they don't, then ultimately any risk that sits in terms of the tax risk is with the client rather than them. As a minimum, you should say, well, actually, I would be saying if you don't get a status determination statement, you should absolutely be asking for one. And saying, you're legally obliged, and reminding the client that they're legally obliged to actually provide that to you. So then you do have something that sets out the reasons. I think just as a sort of a side point, but relevant, I know when the public sector rules came in, a lot of public sector bodies essentially just took a blanket view and said, well, we're just going to treat everybody as if they're a deemed employee and I'm going to withhold pay as you earn. And the revenue have been very clear that that's no more acceptable than treating everybody as and ignoring the situation and treating everybody as a deemed contractor. So the revenue will be looking out for people who have gone too far to the other extreme, and actually, taking a blanket approach to bring everybody within the rules, just as they will be looking at people who kind of effectively saying that they've fallen outside, they're taking a blanket approach or just ignored the rules. So hopefully there will be a degree of protection, and we do have to expect, soft landing or not, that the revenue will have a lot of compliance activity around this.
So one from Trudy, if you are a PSC contractor to a small, medium company and HMRC deem you to be employed following an investigation, is there any comeback on the end user for holiday pay, etc., as deemed employed?
I'll take that one. The short answer is no, because as long as the end user's contracting genuinely with a service company, the individual providing the services can't be its worker or employee, because there's no actual contract for personal service with the individual, and therefore any claim for holiday pay from the end user should fail. They should. I was recently involved in a case where a judge managed to find to the contrary. He found there was no employment relationship because there was a service company in the middle, but there was a worker relationship directly between the end user and the individual. That's absolute nonsense, and that case will be appealed. So the correct answer is no. You can never guarantee a judge won't make a mess of it, but there's always the appeal tribunal if they do.
That's very helpful. And then one last one to do with outside of the UK. Working for a global company, am I right in understanding the only way to avoid IR35 if there's no presence in the UK? No at all.
So, yeah, I mean, I think going back to first principles, pay-as-you-earn only applies where the payer has a business presence in the UK. So if you're providing contract service, and this is something I have to admit that, you know, I haven't looked at in detail in respect to these rules, but I think the general principle does apply that if the engager, the client, has no business presence in the UK, then the IR35 rules, in the sense that they've got to issue a status determination statement, effectively fall away, because there's just no obligation on them to withhold pay-as-you-earn in that sort of situation. It may, however, be in that situation that you then have to go back to the old version of the rules, which is essentially to say that you've got to self-assess as a PSC to decide whether the rules apply to you or not. But it's kind of driven by the business presence of the client rather than the PSC, if that makes sense. So.
Those are all your questions. I think it's been really, really helpful.
Great stuff. Thank you, Alice. Look at that, bang on time as promised, just about 12 o'clock. So once again, thanks very, very much for everybody for joining us this morning. I hope you did find it useful. Again, Alice will shoot me if I don't remind you that there is the feedback form. So please do complete those. It's really useful to help us to understand how we can make these events, you know, as good as possible for those attending. But otherwise, you know, I think the contact details for John, Jenna, and myself are all in the slides. So if there are any issues you'd like to raise, then please by all means give us a shout. But otherwise, thanks very much for your time, and enjoy the rest of your day.